Hello, my name is Mike Tesoro and I prepared this ACCC case note entitled Maxing Out ACCC and J Hutchinson Pty Ltd. The reason I've called it Maxing Out is because I think the case is significant in signalling a change in the way the federal court's going to be approaching the imposition of pecuniary penalties in cases where a respondent, has engaged in numerous breaches of the legislation. Now, a bit of background about myself. I'm a competition and consumer lawyer, and I've been running my own practice Tesoro Legal Consulting for the last 14 years, and I help companies with competition and consumer law matters. Prior to that, I worked at the ACCC for 15 years and had a variety of roles, including a director of enforcement. And one of the things I did in that role was run the ACCC's waterfront investigation team during the waterfront dispute. So I commenced proceedings on a few secondary boycott cases against the Maritime Union of Australia. Outline of the presentation, start with the introduction, then discuss the liability judgment of Justice Downes, then look at the penalty judgment, which also includes some consideration of injunctions, adverse publicity orders and compliance program, then finish with some commentary. Now, the ACCC commenced legal proceedings against Hutchinson and the CFMMEU about these boycotts in December 2020. But the conduct actually relates to the CFMEU. So subsequent to the conduct being engaged in, the CFMEU merged with the Maritime Union of Australia to become the CFMMEU. And the conduct involved a boycott threat against Hutchinson in relation to the use of a subcontractor on the South Point A apartments in Brisbane. And the ACCC alleged that Hutchinson had breached 45E and 45EA of the Competition and Consumer Act, and that the CFMEU had been an accessory to that conduct. Now, looking at the provisions, they're a bit different to some of the other provisions in the boycott section. The main difference is that 45E requires proof of a purpose. So where it differs from the other secondary boycott provisions is that the other ones require the ACCC to prove both purpose and effect or likely effect, whereas in this particular section they only have to prove purpose. And as you can see, the essence of it is that the union pressures an individual organisation to cease supplying or requiring goods from a third party in order to have industrial peace on their particular work site or in their business. A few other elements of 45EA. The first is that there has to be an arrangement in existence where a company is accustomed to supply or have goods or services acquired from it. So it doesn't apply to a company that has had no dealings with the first party. And the way they determine whether there was an accustomed to supply or acquire is if they're a regular supplier of products or services, the latest supplier, or they've been a supplier in the last 3 months. The 45EA is the give effect provision to the 45E making the arrangement, and it's notable that under 45E there are no exceptions or defences that apply under 45D, 45DA and DB, where there are defences in relation to employment conditions, environmental, consumer protection and so on. Finally, the maximum penalties for the breach of this provision are $750,000. Now, the facts are that Waterproofing Industries was retained by Hutchinson to do some subcontract work in Queensland on the South Point project, but the company did not have a bargaining or EBA with the CFMEU, which the CFMEU was very unhappy about. They complained about it. They also complained about not being consulted by Hutchinson prior to retaining or subcontracting with the waterproofing company. Shortly after that, the CFMEU threatened to engage in industrial action if Hutchinson didn't cease using the waterproofing company. And then in July 2016, the waterproofing company was excluded from the site, and subsequently their subcontract arrangement was terminated. Now, this is a pretty garden variety boycott. There's not a lot of sophistication to it, and so the judge had no difficulty in determining that Hutchinson had breached section 45E by making an arrangement with the CFMEU to cease using the relevant waterproofing services from WPI at the South Point project. And furthermore, the judge found that Hutchinson had given effect to that agreement. So it was a pretty straightforward case in the liability issue. Also, it was quite straightforward in finding CFMEU liable as an accessory. So the court found that they had been only concerned in the formation of the agreement and also the giving effect of the agreement, and further that the CFMEU had induced Hutchinson's contravention by threatening or implying that there would be conflict with or industrial action by the CFMEU if Hutchinson continued to use the particular company. We just move to the penalty decision. The judge opens up her discussion of the penalty issue with these observations about the industry, and she notes that there are a lot of companies in the commercial construction industry that would be potentially engaging in conduct of a similar nature to that engaged in by Hutchinson. She notes there that there was considerable scope for conduct to occur of the kind which was engaged in by Hutchinson. She notes that conduct would be very damaging to the competitive process, but importantly, it would often be clandestine, so it wouldn't come to the attention of the regulator and the courts. So I think the implication there is she's saying, well, this conduct probably happens quite extensively in the industry, rarely is it picked up, so there's a need to take a firm view on it in this particular case. And then she refers to the need to counter any perception in the industry that it's worthwhile engaging in these types of agreements with unions because of the benefits which would flow from unlawful conduct. So it's all leading up to a large penalty being imposed to try and stamp out the conduct. So I thought they were interesting observations to make at the commencement of a penalty decision. Then she seeks to distill the findings from ACCC v Patterson, and that's a High Court case which was decided earlier in the year, which again involved the CFMEU engaging in boycott activity. And in that case, there are a number of important principles that were identified, which she summarises in her judgment. The first is that the purpose of civil penalty provisions is primarily, if not solely, the promotion of the public interest in compliance with the provisions of the Act by the deterrence of further contravention. So the High Court made it very clear that that is what civil pecuniary penalties are all about, achieving deterrence of further contraventions. She then notes that there is no place for the notion of proportionality in a civil penalty regime. So this is a criticism of a number of cases in the past where they've seen the maximum penalty as reserved for the most serious conduct imaginable, and therefore the conduct before the court in a particular case had to be measured against this archetypal most serious conduct. And the High Court clearly stated in the Patterson case that notion of proportionality is not correctly applicable to civil penalty regimes, and so should be dismissed as a consideration. Then she notes that civil penalties must be fixed with a view to ensuring that the penalty is not regarded as an acceptable cost of doing business. So clearly penalties have to have a sufficient sting in them to ensure that companies learn from their conduct and cease engaging in it. Then she refers to the French factors from the CSR case and states that it is relevant to consider these various factors, but it should not be considered a legal checklist which the court has to consider. And I think that's important because I think they've often been applied as a de facto statutory legal checklist in many cases. Then the next observation is that the maximum penalty which might be imposed must be balanced with all other relevant factors, and that's a reference to the Makarian case, which was a criminal case that went to the High Court that spoke about the need to identify the maximum penalty set out by the legislature for a particular contravention, but then to also look at all other relevant factors before deciding on the penalty to impose. The next observation is pretty obvious. I think that the power to impose a penalty should be exercised judicially, fairly, reasonably, having regard to all the relevant factors, which is an obvious observation. The next issue is interesting because she says that the High Court found that the proposed penalty should be proportionate in the sense that it strikes a reasonable balance between deterrence and oppressive severity. So there is a legitimate place for proportionality in civil pecuniary penalties, but it is in terms of balancing up the impact of a penalty in terms of achieving deterrence as opposed to being oppressively severe on a company or individual. The next issue she identifies with concepts such as totality, parity, and course of conduct are relevant in the assessment of a civil pecuniary penalty. Now, they're all concepts from the criminal law, so even though they're criminal law concepts, they're appropriately used in the determination of a civil pecuniary penalty. Then she says that the High Court concluded that a court is empowered to impose an appropriate penalty and must act fairly and reasonably for the purpose of protecting the public interest by deterring future contraventions. So this is a restatement probably of the very first principle that she listed in her list of 10 principles. And the final issue, that's probably the most important one, is that in considerations of deterrence and the protection of the public interest, that it may result that the imposition of the maximum penalty is the only alternative where the court believes that no lesser penalty will be an effective deterrent against future contraventions. So what she's saying there is that the High Court in Pattinson concluded that if the judge believes that the only way to achieve deterrence and to stop future contraventions is to impose the maximum fine provided for under the legislation, then that's what the court must do. Now that has very big implications for the penalties which apply under the Competition and Consumer Act and Australian consumer law, which are currently $10 million, 3 times the benefit, or 10% of turnover, and they're going to become potentially even more significant if the Labor government's proposals to increase those penalties get through Parliament, which will mean that the base penalties increase to 50 million and the 10% of turnover is increased to 30% of turnover. Now, the judge determined that Hutchinson had engaged in the conduct which fell squarely within the mischief to which the relevant provisions were directed, namely the capitulation by companies to threaten industrial action to avoid personal loss or damage at the expense of third-party suppliers. So effectively, Hutchinson's conduct fell squarely within these particular provisions and the mischief they were seeking to prevent. When she was determining the penalty that should be applied to Hutchinson, she looked at a range of factors, and some of these are aggravating factors, some are mitigating, and some have a neutral impact. First was that she determined there was some previous conduct by Hutchinson where they had prevented a subcontractor from working on the site due to concerns about the union's views about that supplier, and that wasn't actually under the Competition and Consumer Act but other legislation, but it was relevant conduct because it was similar, very similar to the conduct engaged in the present case. However, there were no breaches of the Competition and Consumer Act, so that's obviously a factor in their favour. Other factors in their favour were that the conduct occurred over a short period of time, and there were other subcontractors working on this particular site who did not have EBAs, and they were permitted to work. So that was a factor that counted in their favour because it obviously wasn't a blanket prohibition on companies working on the site. There was also no evidence of loss or damage, which is not to say there wasn't loss or damage, there was just no evidence submitted to the court on that issue. The revenue of Hutchinson was quite large, 2021, $2.6 billion of revenue, so that obviously meant that a larger penalty should be imposed, so there would be some sting on the corporation from a larger penalty. The court also was satisfied that senior management of Hutchinson had been involved in the conduct. The culture of compliance was a issue that went both ways a bit. On the one hand, there didn't appear to be a strong culture of compliance before the breach. Also, subject, following the ACCC investigation, the company didn't seem to implement a compliance program, but they had taken steps since the liability judgment and had implemented a program. So on balance, I think that actually assisted Hutchinson to achieve a lower penalty. It was also interesting that the judge thought that a negative factor was the fact that Hutchinson had not reprimanded the senior staff who'd been involved in the conduct, which seems appropriate once the court has held that the conduct was illegal, but that hadn't happened. And then finally, there'd been limited cooperation and a lack of contrition. Now, both of these factors didn't hurt Hutchinson in the sense they weren't aggravating factors, but limited cooperation means you don't get the benefit of cooperating with the regulator and cooperating during the course of the litigation, which can result in a big discount off the penalty, and there was no evidence of contrition. So that's often evidenced by a senior manager putting on an affidavit at the penalty hearing expressing contrition, and that didn't happen. That would have also potentially reduced the penalty by some amount. So what the judge ultimately decided was that there were a couple of courses of conduct. They were inextricably interrelated, and therefore the penalty which the ACCC was seeking was, in her view, too high, and that if she'd agreed to the penalty being sought by the ACCC, it would have been a penalty of oppressive severity. And accordingly, for the two events, the making and giving effect of the illegal agreement, she imposed a penalty of $300,000, leading to a total penalty of $600,000. Then she considered the CFMEU's position, and the first issue is the ACCC submitted that the penalty should be $1.5 million. CFMEU countered with a penalty of $250,000. But what the judge noted was in the pleadings, the way it had been set out was that there was really just one course of conduct, very clearly only one event which could be subject to a fine. Therefore, the maximum penalty could not be more than $750,000. Interestingly, the CFMEU did not oppose the adverse publicity orders which were being sought by the ACCC, which one would expect that a company would, or a union would want to avoid adverse publicity orders, but it didn't appear that the CFMEU minded that too much. They did, however, oppose both the imposition of injunctions and compliance program, which they joined with Hutchinson in opposing those two remedies. Now, when the judge looked at the relevant factors, there were quite a lot of factors which went against the CFMEU. There had been previous similar conduct under other legislation, such as the Fair Work Act, the Workplace Relations Act, and so on. So it showed that the CFMEU had engaged in this type of conduct on numerous early occasions. There had also been one previous breach of the Competition and Consumer Act relating to quite similar conduct. So those factors obviously counted against CFMEU in terms of the penalty. The net assets of the company were relevant to imposing a larger penalty. So $11.8 million net assets for the national office and $2.7 million for the branch. Senior management were not found to have been involved in the conduct. The culture of compliance within the business was considered to be poor. There was no real commitment to compliance that was evidenced in the case. There was clearly a lack of contrition. There was no statement of contrition about having breached the legislation. Two factors which would have counted in CFMEU's favour was the short period of time that the conduct occurred and the fact there was no evidence of loss of damage. The judge also noted that no disciplinary action had been taken against the staff involved in the conduct, which it seems she believed should have occurred once the liability judgment was handed down, and again limited cooperation. So many of the factors that she considered went against the CFMEU. So she concluded that in the circumstances, the penalty should be the maximum available under legislation. So as I said earlier, there was one finable bit of conduct, so the maximum penalty was $750,000. So she decided to impose the maximum penalty. And she states there, it is apparent from the above analysis that no less a penalty will be an effective deterrent against future contraventions of the like kind by the the CFMEU as well as by others which are in the same position as the CFMEU. So this is a situation where she has weighed up all the factors and said nothing short of the maximum penalty will achieve the purposes of the legislation, which is to achieve deterrence and compliance with the law. So this has very significant implications for other companies which are found to have breached the legislation after a number of previous breaches, because the failure to take heed of the previous penalties and to cease engaging in illegal conduct is going to put courts in the position where they have to genuinely weigh up whether to impose the maximum penalty available under legislation. Now, some other issues were raised in the case. The first was that injunctions were refused by the judge in relation to Hutchinson, and there were some grounds for that. The first being the period of time which had elapsed since the contravention, 6 years. Also that it had been the first contravention of the Competition and Consumer Act by Hutchinson. And furthermore, there'd been no contraventions of the relevant legislation in the 6-year period between the contraventions and the judgment. So they're all very legitimate reasons not to grant an injunction. Finally, the injunctions were framed in such a way that they pretty much parroted the statutory language. So effectively they are injunctions not to breach the law. And it's well established in case law that judges should not be granting injunctions which simply state that an individual or corporation won't breach the law. So on those grounds, the judge declined to make the injunctions. She also declined to make the injunctions in relation to the CFMEU, and these were different reasons. Firstly, she was concerned about the length of the injunctions, which were framed as lasting 7 years. She also believed the scope of the injunctions were too broad, as they referred to any corporation. So they weren't limited to Hutchinson, or they weren't limited to companies in the building industry. They were any corporation. So she believed that they extended beyond the scope of the conduct that had been engaged in and proven in court. It surprised me somewhat that she simply didn't grant the injunctions, because it was clearly open to the court to ask for redrafted injunctions which were shorter in time frame and narrower in scope. And it seems to me that that was open to the judge and probably should have been looked at. Now, the compliance program comments are very interesting. Ultimately, she refused to order the introduction or implementation of a compliance program by either Hutchinson or the CFMEU, and she had 3 primary grounds. First, the compliance program did not, in her view, have a sufficient nexus or relationship to the conduct that the companies had engaged in. It was wider than just simply seeking to prevent repetition of the conduct. Also, it was not proportionate to the established contraventions. So the contraventions were quite narrow, involving one supplier in Queensland on one site, but the compliance program sought to introduce a company-wide series of measures. Thirdly, the compliance program was not expressed with sufficient precision, so that it was able to be performed and to enable the breach of the order to be ascertained. So she thought it was all a bit too vague. Now, she made a few further comments. Firstly, she referred to the risk assessment, which has included the compliance program, and said that it's a bit vague, but also there did not appear to be any mechanism whereby the recommendation from the risk assessment would be implemented, and that there'd be reporting on whether those recommendations had been implemented. There was also a concern that this policy statement, the compliance policy, wasn't in any way explicitly connected to the results of the risk assessment. Furthermore, she was concerned that the program did not appear to require the respondent to comply with the policy that they had implemented. And also she was concerned about the absence of guidelines about the annual training that had to be provided to the staff, and it was not stated expressly and with sufficient clarity what the respondents would have to do in relation to training. And the final thing, probably the most embarrassing aspect of it, the ACCC in the attachment actually referred to a superseded standard. So the guidelines for complaint management and organisations which is Australian New Zealand standard, was superseded a number of years ago by an international standard. So that was obviously a mistake. Now, make some comments about this. Firstly, it is apparent that the maximum penalties will be on the table for repeat offenders, and that's going to be of major concern because the penalties currently under the Competition and Consumer Act and the Australian Consumer Law are enormous, and they look like they're going to become much bigger. So repeat offenders have to be very careful next time they get taken to court, because there's going to be a strong argument that the maximum penalty should be imposed. Excuse me. And there are a number of companies that jumped out in my mind that need to be particularly careful. I think Optus, Telstra and Woolworths, who have all been sued multiple times by the ACCC for consumer law breaches, and in Woolworths' case, consumer and competition law breaches. So they're going to be particularly careful, because next time they get before a court, I'm sure the ACCC is going to be arguing the maximum penalty should be imposed. Also, there are even more serious implications if some current legislation, which is being proposed by the Labor government, is introduced, which is to increase the level of pecuniary penalties both under competition and consumer laws to a base penalty of $50 million or 30% of turnover, whichever is the highest. So this is going to become very serious for repeat offenders in the future. I think it was important to see that injunctions are not granted as of right. The regulator has to make a good case for them, and clearly in relation to Hutchinson there was not a good case for injunctions, given it appeared to be some isolated conduct. The company itself had not engaged in extensive breaches of legislation and had not engaged in any further contravention legislation since the conduct 6 years ago. I thought the decision not to grant injunction in relation to CFMEU was somewhat odd, given that the complaints which the judge had about the claimed injunctions were really about their scope and length, which could have been clearly remedied by narrowing the scope, shortening the term. And I think some injunctions on the CFMEU not to engage in this particular conduct would have been very helpful and quite needed, given their record of contraventions in the past. The final issue that I think is very interesting is the judge's observations about the compliance program obligations. Now, it seems to me that she's made a number of comments about how the compliance program is vague, unclear, and I guess on a reading of the documents you might come to that view, but the practical fact is that these compliance programs have been implemented hundreds of times over many, many years, and companies do understand them and do know what to do. They do work, and I think some of the issues that she has raised about the compliance policy seem to arise from a failure by the ACCC to put on evidence to explain how this compliance policy and program was supposed to work. So I think it's a call out to the ACCC that in future they just can't hope to get orders for compliance programs without putting on some evidence to just explain how they're going to work, the benefits of them, and clearly some of the observations the judge had made about how difficult they're made to be implemented were based from a lack of knowledge of how they actually work in practice. For example, she was very concerned that the number of documents that the reviewer who looks at preparing the risk assessment would have to have access to would be enormous, but in reality there's a relatively narrow range of documents which a risk assessor has to look at. Also, the fact that the risk assessment recommendations aren't explicitly required to be implemented by the company is something that the ACCC needs to look at going forward. I think it's an opportunity for the ACCC to look at its templates and to tighten them up to address some of the concerns that the judge raised in this particular case. I think it's pretty well accepted that compliance programs are very worthwhile things for companies to introduce, that they do help identify problems, and the fact that they weren't in this case, particularly with the CFMEU, is a concern, but something that can be remedied by the ACCC going forward by doing two things. Firstly, putting on evidence, explaining how the policy is going to be put together, how it's going to be designed, and secondly, looking at the templates and making sure all the bits fit together more seamlessly. So that's all I had. Hopefully that's been helpful. If you have any questions about this particular presentation, feel free to give me a call or send me an email. Bye-bye.